Greetings, everyone. Thank you for joining us for today's webinar, AccuSourceHR's 2023 Mid-Year Compliance Update webinar. My name is Danielle Olivier, Marketing Generalist here at AccuSourceHR, and I will be your moderator today. I'd like to take this opportunity to introduce today's presenter, Jennifer Damon, Director of Compliance and Chief Privacy Officer at AccuSourceHR. Jennifer graduated from the University of Akron School of Law with a Doctor of Law degree and has over 10 years experience in the background screening industry. She is an experienced compliance professional with knowledge from both the employer and consumer reporting agency sides. She has performed various roles in the industry, including interpretation of criminal and civil record summaries, managing quality control, and managing the E-Verify program, including audits for a billion-dollar facility services company. She has experience with government clearances and contract review. Jennifer is responsible for AccuSourceHR's compliance department, including federal, state, and local legislation changes and industry accreditation. Additionally, she oversees the quality assurance process. I will now turn the presentation over to Jennifer.
Thank you so much, Danielle. Good morning, everyone, or good afternoon, depending where you're joining us from. Welcome to the Mid-Year Compliance webinar. We'll be discussing a variety of topics today, and I will be answering questions at the end of the presentation. Please send any questions you have, and I will address as many of them as possible, or will follow up through email if we run out of time. I swear I blinked, and 2023 is already halfway over. It's been a busy 6 months, and as usual, AccuSourceHR has numerous background and drug screening updates to provide. Today, we'll be covering the newest in Ban the Box and Fair Chance legislation, salary transparency, new privacy laws, and marijuana and related developments. We will finish up by discussing changes and trends that we anticipate for the remainder of 2023 and beyond. We will also share best practices to ensure your background and drug screening programs are compliant. As always, please keep in mind that this webinar is informational only. Even though I'm an attorney, I am not giving legal advice. We do recommend that you seek the advice of qualified counsel, preferably specializing in employment law, especially background screening, prior to engaging in any legal decisions involving drug and/or background screening policies or compliance concerns. Our first topic is fair chance legislation, also referred to as ban the box laws. These types of laws prohibit employers from asking about criminal convictions before a certain point in the hiring process, usually before a conditional job offer is made or before an interview is held. The goal of fair chance laws is to allow applicants with prior convictions to not only obtain an interview, but also move forward to a certain stage in the hiring process before they're asked about their criminal history. Sometimes these laws can also require that an employer start the background check process later. A majority of the US population is impacted by ban the box laws. In other words, if your organization isn't already subject to them, it's highly, highly likely that you will be in the future. To start, the City of Chicago recently updated its existing ban the box law, with updates becoming effective immediately as of April 24th. The amendments now apply the ordinance to almost all Chicago employers, and there are new assessment and notices that are required. The ordinance now applies to all employers that have at least one employee, and they are required to either 1, have a Chicago license to conduct business, or maintain a facility within Chicago. So it could be either or it could be both. The Chicago ordinance now requires specific treatment of arrests and convictions. Employers cannot ask about or use arrest records to take adverse employment action. Arrest records are defined under the ordinance to include arrests not leading to conviction, juvenile records, and criminal history information that has been expunged, sealed, or impounded. There are exceptions, including where a criminal background check is legally required. If an employer wants to take adverse action based on a conviction, it must conduct an individualized assessment. The ordinance prohibits employers from taking adverse action based on a conviction unless applicable law requires the exclusion of the individual from the position based on a conviction record. Or another exemption is if the position requires a bond and the conviction prevents the individual from becoming bondable. Another exception is where there's a substantial relationship between one or more of the individual's criminal offenses and the position. And then finally, if there's an unreasonable risk to property or the safety or welfare of others or to the general public. One of the permitted uses of a conviction is where a substantial relationship exists. To make that determination, employers must consider 1, the length of time since the conviction, 2, the number of convictions, 3, the nature and severity of the conviction and its relationship to the safety and security of others, 4, the age of the individual at the time of the conviction, 5, the unique circumstances surrounding the conviction, and 6, any evidence of rehabilitation efforts. The Chicago Ordinance also has specific requirements that an employer must do when it plans to take adverse action. If the employer makes a preliminary decision that a conviction record disqualifies the individual from employment, the employer must provide a written notice that contains the following information. First, a description of the disqualifying conviction or convictions, along with the employer's reasoning for the disqualification. 2, a copy of the conviction record. And 3, an explanation of the individual's right to respond to the notice at least 5 days prior to the decision becoming final. And that any response can include evidence challenging the accuracy of the conviction record or mitigating evidence, such as evidence of rehabilitation. After the employer considers any response or information provided by the individual, but the employer still determines that the individual is still disqualified, the employer must then also provide a final written notice of adverse action. This notice must describe the disqualifying convictions, identify any internal recourse the individual may have to appeal that final decision, and state that the individual has the right to file a complaint with the Chicago Commission on Human Relations. Moving on to Louisiana, the parish of East Baton Rouge and the city of Baton Rouge have enacted their own Fair Chance Ordinance, which became effective on May 10th of this year. The ordinance expands existing Louisiana law to cover city and parish contracting jobs. It applies to any contract, cooperative endeavor agreement, or grant that is executed on or after April 1st, 2023. Or any renewals that occurred after that same date. Any of those contracts must include fair chance hiring compliance requirement, meaning that the contracts must require that contractors comply with the ordinance. What are the restrictions? A contractor cannot request, either verbally or in writing, the disclosure of criminal history information before extending an offer of employment to an applicant for work under a covered contract. Criminal history includes questions related to arrests, convictions, or pending charges. The contractor must also limit its consideration of an applicant's criminal history. A contractor may consider criminal history before making an offer of employment if it's required to do so by law, or if the contract involves a city or parish department that's specifically listed in the ordinance. So for example, law enforcement's included, so they wouldn't have to follow those procedures for law enforcement positions. The city parish will create a procedure where an applicant can submit a complaint about non-compliance. And keep in mind too, that non-compliance could result in non-payment under the contract. So in other words, if the city decides that you are not complying with the contract and that requirement, they could choose not to pay you under the contract. So very important to come into compliance so you get paid. Just after our year-end webinar, the city of Gainesville, Florida passed its own Fair Chance law. It became effective immediately on December 22nd, 2022, and it applies to any employer with 15 or more employees. The ordinance prohibits an employer from asking questions regarding criminal history until the employer has made a conditional offer of employment. Additionally, the employer cannot request a background check until after a conditional offer is made. An employer cannot take adverse action unless it determines by performing an individual assessment that the applicant is unsuitable for the job based on their criminal history. An employer who decides to take adverse action based on criminal history must take certain steps to be in compliance. It must inform the applicant of the decision, provide a copy of the criminal history it used to make that decision, provide the applicant with a reasonable opportunity to provide additional information or context, including any rehabilitation, and must also provide a statement that the decision was made based on the applicant's criminal history. Importantly, this law also requires that the notice includes mandated behavior or mandated language contained within the statute. A first violation of the ordinance will cost $500, with half of it being given to the complaining party. Each subsequent violation is $500. We will now shift our focus to salary transparency and related topics. New York State recently passed S 9427A, which amended New York's labor law. Effective as of September 17, 2023, employers will be required to disclose compensation or a range of compensation when issuing a new job opportunity, promotion, or transfer. The range can extend from the lowest to the highest hourly rate, wage, or salary that an employer believes in good faith that it would pay at the time of posting. A wage range is not required for commission-based positions where pay is based solely on commission. However, the employer must disclose that information. An employer must provide a job description if it already has one available, but it's not required to create one just for this purpose. The law applies to all employers with 4 or more employees for positions that can or will be performed, at least in part, in the state of New York. The advertisement must also include a job description if one exists. Note that the law specifically excludes temporary firms and temporary employment. A party claiming that it has been injured by a violation of the law can file a complaint with the New York State Commissioner of Labor. Employers who violate the law may face various civil penalties based on whether the violation was its first or a subsequent violation. In determining the amount of the penalty, the commissioner may consider the employer's size, good faith efforts to comply, any history of previous violations, and the gravity of the violation. The good news is that there's no private right of action available. So interestingly, before New York's pay transparency law went into effect, it's already been amended under A 999/S1326, which was signed on March 3rd. The effective date of September 17, 2023 under the original law is still the same. This amendment modifies the scope of covered jobs, eliminates the record-keeping requirement, and clarifies the definition of advertise. The prior version of the law had included all remote jobs because the way that it was worded, technically any remote job could have been performed in New York State. The amendment also updated the wording to apply only to those jobs that will be physically performed in New York. It also includes any job, promotion, or transfer that will be physically performed outside of New York, but where that person's going to be reporting to a supervisor, office, or other work site in New York. Be really, really careful with this last part because it seems that there's jobs that have no ties to New York, but they could still require compliance if that person is reporting to a supervisor who him or herself is based in New York. So be very, very careful when you're looking at that. The amendment also updated the definition of advertise, which now means to make available to a pool of potential applicants for internal or public viewing, including electronically, a written description of an employment opportunity. The amendment also updated requirements for positions based solely on commission. While the general requirement remains the same, it now applies to employers, employment agencies, employees, or agents thereof who are advertising for opportunities paid solely on commission. Finally, the prior version of the law had imposed record-keeping requirements on employers, but those requirements have been removed. Columbus, Ohio has joined Toledo and Cincinnati in enacting a salary history ban. The new law applies to all employers located within the city of Columbus that have at least 15 employees within the city. It includes job placement and referral agencies and other employment agencies. Applicant is defined as any person applying for employment within the geographic boundaries of the city of Columbus, and whose application, in whole or in part, will be solicited, received, processed, or considered in the city of Columbus. Under the new law, covered employers cannot ask about an employment applicant's wage or salary history or screen them based on that information. Doing so would result in an unlawful discriminatory practice. The law specifically excludes any objective measure of that individual's productivity, such as revenue or sales. Employers cannot rely solely on salary history when deciding whether to hire or when determining compensation. They also cannot retaliate against an applicant who refuses to disclose salary history. Employers are permitted to discuss expectations about salary, benefits, and other compensation. Columbus employers are not required to share the pay scale for a position with applicants after conditional employment offer. The law does have some exceptions, and it does not apply to any actions taken by an employer under any federal, state, or local law that specifically authorizes reliance on salary history to determine an employee's compensation. Another exception, it does not apply to applicants for internal transfer promotion, and it also doesn't impact salary history information that is voluntarily disclosed by an applicant. Additionally, it doesn't apply to any attempt by an employer to verify an applicant's disclosure of non-salary related information or to conduct a background check. So for example, you can still do an employment verification, even though sometimes you might think, well, you're gonna get salary information. That's not necessarily the case and it's exempted. It also excludes applicants who are rehired by the employer within 3 years of the most recent termination date, positions that fall under collective bargaining, and federal, state, and local government employers except for the city of Columbus. So as you can see by that pretty long list, there's a bunch of exceptions to this law. Applicants can file a complaint with the Columbus Community Relations Commission, and they can face civil fines of $1,000 up to $5,000. On June 5th, the Governor of Colorado signed SB 23-105, which amends Colorado's Equal Pay for Equal Work Act. The updated law will have a significant impact on an employer's obligations when posting jobs and promotion notices in Colorado. Starting January 1st, 2024, employers must internally announce new hires and promotions, including the name, former job title, and new job title of the selected candidate. Employers must also provide information on how employees can demonstrate interest in similar opportunities in the future. This notice must be made within 30 calendar days of the candidate's start date. Employers are no longer required to provide this notice when a promotion is based on career progression or career development. These are not considered job opportunities because the employer does not have a vacancy to be filled, either from a newly created position or vacated position. For external postings and promotional notices, employers must list the date they expect to close the application window. Note that this notification requirement does not have a geographic limit. As written, it appears to apply to any job opportunity, not just opportunities for candidates working in Colorado. However, under the amended law, employers with no physical office in Colorado and who have fewer than 15 Colorado-based employees will be required to provide their Colorado employees with notice of a remote job opportunity only, rather than all promotional opportunities throughout the entire company. This will be in place until July 1st, 2029. Employees will be able to recover back pay for violations going back 6 years instead of the previous 3 years that was enacted previously. However, claims still must be brought within 2 years of the alleged violation. Additionally, the Colorado Department of Labor will create an investigation and mediation process for wage discrimination claims. Let's move on to privacy law. We entered 2023 with 5 states that had passed comprehensive privacy laws. It's been really busy the first half of the year with that count doubling. Let's start with Iowa. Iowa joined the privacy parade when Senate File 262 was signed into law on March 29th. The act relating to consumer data protection goes into effect on January 1st, 2025. It's pretty similar to other existing privacy laws, though it's not as broad as California's newest law. First, a note on definitions. Consumer is defined as a natural person who is a resident of Iowa who is acting in a non-commercial and non-employment context. The Act also defines controller and processor in the same way that other privacy laws do. Personal data is defined the same as any information linked or reasonably linkable to an identified or identifiable natural person. That is a mouthful to say. It does exclude de-identified data, aggregate data, and publicly available information. Sensitive data is defined by the Act to include racial or ethnic origin, religious beliefs, mental or physical health diagnosis, sexual orientation, citizenship or immigration status, genetic or biometric data, personal data of children, and precise geolocation data within a radius of 1,750 feet. As with other US privacy laws we have seen so far, Iowa also has applicability thresholds. Companies are subject to law if they do business in Iowa or target products or services to Iowa consumers. They must also meet one of the following criteria during a calendar year. Either control or process the personal data of at least 100,000 Iowa consumers, or control or process the personal data of at least 25,000 Iowa consumers and derive over 50% of the gross revenue from the sale of personal data. It's important to note that Iowa does not have a revenue-based threshold like some of the other laws that we see have. It expressly applies only to consumers acting in an individual or household context and excludes anyone acting in a commercial or employment context. As with other US privacy laws, Iowa provides entity level and data level exemptions. For example, if data is already covered under the Fair Credit Reporting Act, it is exempted from compliance with Iowa's Act. Iowa also exempts data processed or maintained for employment purposes. Certain entities are also exempted from the Act, including government entities, financial institutions, entities subject to HIPAA or other privacy laws under the health system, nonprofit organizations, and higher education institutions. Iowa requires transparency in processing, which businesses can meet by providing a privacy notice. The notice must include the categories of personal data processed, the purposes for which personal data is processed, how Iowa consumers can exercise their consumer data rights, the categories of personal data shared with third parties, and the third parties with which personal data is shared. There are no specific requirements as to how notice must be provided, and it does not require specific reference to Iowa, meaning that a separate policy for Iowa will likely not be necessary. And that in turn really helps because it's one less unique policy that needs to be provided. The Act provides consumers with the following data privacy rights: which is actually less rights than some types of rights found in other laws. First, the right to confirm whether a controller is processing a consumer's personal data and the ability to access their personal data, also known as the right to access. The right to obtain a portable copy of personal data previously provided to the business, or the right to portability. The right to delete personal data provided to the business by the consumer, or the right to delete. And fourth, and finally, the right to opt out of the sale of personal data, which is defined as an exchange of data for monetary consideration, also known as the right to opt out. Note that the right to opt out of sale does not apply to disclosures made to a processor, disclosures made to a controller to fulfill a consumer's request, and disclosure made by a consumer to a public channel or internal transfers. It also does not apply to pseudonymous data. Consumers can exercise their rights by submitting a request to the controller as provided in the privacy notice. Controllers have 90 days to respond, but may extend that period by 45 days when reasonably necessary. The Act includes specific contractual requirements that must be included in agreements between controllers and processors. The agreement must provide instructions for processing personal data, specify the nature and purpose for processing, the type of data subject to processing, the duration of processing, and the rights and duties of both parties. The contract must also outline processes for data retention, deletion, access, and subcontractor accountability. Interesting to note, Iowa does not require data protection assessments, which is getting pretty rare with all the laws that are passing to not have that requirement. Controllers should consider the following information. First, they should limit processing to the purpose for which they need to process the data. Controllers must also focus on data security to protect personal data. Iowa requires that consent be a clear affirmative act that indicates a consumer's freely given, specific, informed, and unambiguous agreement to the processing of their personal data. If a controller wishes to process sensitive data for non-exempt purpose, it must provide the consumer with clear notice and an opportunity to opt out. For children who are known to be under 13 years old, opt-in consent is required. I want to finish up this review of Iowa's privacy law by pointing out that non-compliance can be very pricey. While there's no private right of action, which is a good thing, the Iowa Attorney General can demand a civil penalty of up to $7,500 per violation if the business cannot fix the violation during a 90-day cure period. So before we move on, and due to time constraints, honestly, I could spend the entire webinar talking about privacy laws because there's a lot of information. So for the remainder of our review of the new laws, I'm going to point out mainly any differences between Iowa's law and the remainder of the new state privacy laws. So Indiana became the 7th state to pass a privacy law when the Indiana Consumer Data Protection Act was passed on April 13th, and it goes into effect on January 1st, 2026. The coverage thresholds are very similar to those in Iowa. A company must conduct business in Indiana or target products and services to Indiana consumers. It must also either control or process the personal data of at least 100,000 consumers or control or process the personal data of at least 25,000 consumers and derive over 50% of gross revenue from selling personal data. The Indiana Consumer Data Protection Law includes the same entity level and data level exemptions as Iowa. However, Indiana's privacy law provides a few more rights to consumers than Iowa. Indiana data subjects have the right to correct the data and the right to opt out of profiling through solely automated means. Consumers are also given the right to appeal that business's denial. Consumers are also given the opportunity and the right to appeal if a business denies its data privacy right request. The controller must also respond within 45 days of that data privacy right request. and may extend that time frame out by another 45 days if additional time is needed. I discussed considerations for controllers earlier, such as purpose limitation and transparency. Generally, Indiana has the same requirements as Iowa. However, Indiana requires data protection impact assessments as part of the data security process. So controllers must conduct data protection impact assessments for the following activities: for the processing of personal data for targeted advertising purposes, for selling personal data, for processing personal data for profiling purposes if that profiling creates a foreseeable risk of unfair or deceptive treatment or impact on consumers, financial, physical, or reputational injury, a violation of consumer privacy, or other substantial injury to consumers, for processing sensitive data, and for processing any personal data in a way that heightens the risk of harm to consumers. Similar to Iowa, there is no private right of action. However, the Indiana State Attorney General, which has exclusive enforcement authority over this law, must provide a business a notice of an alleged violation and give the business 30 days to cure it. If the violation is not cured within 30 days, at that time, the State Attorney General can bring an enforcement action. As I mentioned earlier, there's no private right of action, which is definitely helpful in this case. Tennessee became the eighth state with a comprehensive privacy law when its governor signed Senate Bill 0073 into law on May 11th. The Tennessee Information Protection Act, or TIPA, becomes effective on July 1st, 2024. The coverage thresholds are similar to those in Iowa and Indiana. A company must conduct business in Tennessee or target products and services to Tennessee consumers. During the calendar year, it must also either control or process the personal data of at least 100,000 consumers or control or process the personal data of at least 25,000 consumers and derive over 50% of gross revenue from selling personal data. As said, very similar to the ones we discussed earlier. It includes the same entity level and data level exemptions as Iowa and Indiana. Consumer is also defined in a similar way, which is defined as a natural person who is a resident of Tennessee and who acts only in a personal context. Personal information is defined very broadly, and the law includes an in-depth list of what's protected. If you can think of a specific type of personal information, chances are it's included on that list. Some examples include real names and alias names, identifiers typically used in background screening, such as date of birth, social security number. It also includes financial, medical, health insurance information, commercial information, education, employment information, and really there's so much more that's included. It's a very big list. So what can consumers request when it comes to their personal data? Consumers have rights that are similar to Iowa and Indiana, including the rights to access, correct, delete, portability, and opt out of the sale of personal information. They also have the right to request information about personal information the data controller sold or disclosed to third parties. The obligations of controllers under TIPA are similar to those discussed earlier, along with standard obligations that are found in other US privacy laws. Controllers under TIPA must respond to data privacy requests as soon as they receive them, but no longer than 45 days. Of special note is the requirement for a controller to complete a data protection assessment for certain types of processing activities. It's pretty similar to what we just talked about. It includes targeted advertising, sale of personal information, processing for purposes of profiling, where it presents a foreseeable risk, sensitive data, and where there's a heightened risk of harm to consumers. Controllers must also meet privacy notice requirements, and they also have, processors also have obligations under the TIPA, which includes following the instructions of the controller. Contracts between controllers and processors are required, and they have to contain certain clauses. The authority to enforce TIPA lies exclusively with the Tennessee Attorney General and reporter. Interestingly, the law requires controllers and processors to create, maintain, and comply with a written privacy program that reasonably conforms to the National Institute of Standards and Technology, or NIST privacy framework. If you're able to maintain a program that complies with NIST, it actually provides an affirmative defense against any claim that you have violated that law. Right now, it's unclear if you fail to create a program that complies with NIST, whether that's considered a violation of the Act. So hopefully we're going to get more guidance on whether NIST compliance is truly required. Montana became the 9th state to pass a comprehensive privacy law. Senate Bill 384, or the Consumer Data Privacy Act, was signed into law on May 19th and becomes effective on October 1st, 2024. Like other laws we've covered, Montana applies to a person or company that conducts business in Montana. There's also thresholds where there's the controlling or processing of the personal data of not less than 50,000 consumers. And note that this excludes data that's used solely to complete a payment transaction. Or the other possible threshold is controlling or processing the personal data of not less than 25,000 consumers, where they're deriving more than 25% of gross revenue from the sale of personal data. A consumer is defined under the Montana law as an individual who resides in Montana. It specifically excludes someone who is acting in a commercial or employment context. Similar to other laws, they also have entity level and data level exemptions, including an exemption for data covered by the FCRA. Montana consumers enjoy rights similar to those outlined earlier, including the right to confirmation of whether a controller is processing data and the right to access and/or delete that data. A consumer can obtain a copy of personal data that it previously provided to a controller. It also includes various opt-out rights, including opting out of targeted advertising, sales of personal data, and certain profiling. Controllers must meet certain obligations under the Montana Consumer Data Privacy Act. If a consumer submits a request, the controller has to respond within 45 days. If they are going to respond, they need to provide reasoning within 45 days as well as to why they're not going to comply with that request. They're required to conduct and document a data protection assessment for each processing activity that provides a heightened sense of risk. There's no private right of action, which again is a good thing, and the state attorney general has exclusive authority to enforce the violations. So when I was preparing for this webinar, I originally listed Texas as likely to enact its privacy law. However, it was literally just signed into law on June 18th, so I'm going to provide kind of a brief overview based on what we currently know. HB4, or the Texas Data Privacy and Security Act, will be effective on July 1st, 2024. It also has threshold requirements, which are used to determine if the law applies to an individual person. It excludes monetary levels that are seen in other US laws. Texas has a 3-factor applicability test with some unique factors not seen in other US privacy laws so far. First, the entity must conduct business in Texas or generate products or services consumed by Texas residents. Second, it must process or engage in the sale of personal data. And third, it cannot identify as a small business. As with other laws we reviewed today, it includes entity level and data level exemptions. Texas requires recognition of universal opt-out mechanisms by January 1st, 2025. Consumers must opt in order for a controller to collect and use sensitive data, and can opt out of targeted advertising and sales of personal data. In order to sell sensitive or biometric data, a controller must provide reasonably accessible and clear disclaimers in its privacy notices to notify clients that it may do so. The Texas Data Privacy and Security Act also requires data protection assessments and includes a 30-day cure period that should be reviewed very carefully. Because this law is so new, We'll likely cover it in more depth in the year-end webinar, but I did want to provide a brief overview of it now. Okay, so that was a lot of privacy talk. Let's move on to marijuana and other drug testing updates. Cannabis will always be an important topic for the background screening industry and employers. And during this next section, we will review new marijuana protections, newly legalized medical and recreational marijuana, and related topics. So we talked in our last webinar about marijuana protections coming to California. So I'll just give a very brief overview as a reminder. The law amends the California Fair Employment and Housing Act and goes into effect on January 1st, 2024. Employers will be prohibited from discriminating against an individual in hiring, termination, or any term or condition of employment based on that person's use of cannabis off the job and away from the workplace. There's also drug testing restrictions where an employer cannot discriminate against an individual for testing positive for non-psychoactive cannabis metabolites and basically any bodily fluid or bodily item that's tested. There are some exceptions that we discussed in the last webinar, but in general, employers who don't meet an exception should really prepare to move forward with this as of January. The state of Washington also passed marijuana-related employment protections recently that's going to protect employees. Senate Bill number 5123 is going to go into effect on January 1st, 2024. The purpose is to bring marijuana more in line with alcohol, since both substances are legal. It provides some workplace protections for those who use marijuana while off duty. It doesn't protect all marijuana use, and employers are still allowed to have drug-free workplace policies. Employers cannot refuse to hire a person due to his or her lawful off-duty use of cannabis outside the workplace. Similar to California, Washington employers are not going to be able to rely on pre-employment drug tests that test for non-psychoactive cannabis metabolites. That just means someone recently used it, doesn't mean that they're currently impaired by it. If the employer wants to continue pre-employment testing for marijuana, it must use tests that are scientifically valid and are conducted through methods that don't screen for psychoactive cannabis metabolites. Again, it has to test for current impairment, which is currently an issue. SB 5123 does include some exceptions where marijuana testing will still be allowed, including when testing for purposes other than pre-employment testing, or where they're using a scientifically valid testing that doesn't screen for those non-psychoactive metabolites. There are some exceptions where a state or federal law requires that they're tested or specifies the way that they're tested, or if it's required by a federal contract. The last exception is when an applicant seeks a certain type of position. Typically, these involve security clearances or safety-sensitive positions, and there's others listed in the law as well. Employers are going to be required to identify which positions they consider safety sensitive prior to the applicant's application for employment. Kentucky became the latest state to legalize medicinal marijuana when the law was signed into law on March 31st. It doesn't become effective until January 1st, 2025. It does include a list of qualifying medical conditions, but it's much smaller than what we've seen in other states. However, there is an opportunity for other conditions or diseases to be added as time goes on. An individual who wants to use medical marijuana has to obtain a written certification from a medical practitioner showing that they have a qualified condition. At that point, the individual can apply for a medical marijuana card. So how does this affect employers? Employers can still prohibit the use of medical cannabis by employees. They can also prohibit that card holder from using equipment, machinery, or power tools if they believe that there's a unreasonable safety risk by that person operating them. They can also restrict card holders from consuming medical cannabis or being under the influence while performing certain tasks or being on property. They are allowed to drug test for medical marijuana and act on positive results. And the nice part about this as well is that employers are allowed to rely on the statute to shield them against lawsuit and unemployment compensation costs. I wanted to provide a quick reminder that Maryland's recreational marijuana law goes into effect on July 1st. Those that are over the age of 21 can use recreational marijuana and can use up to 1.5 ounces of marijuana specifically, or 12 grams of concentrated marijuana. They can also grow up to 2 plants per household and can share cannabis with other adults without payment or trade. Keep in mind that the law also has an expungement component of criminal offenses that are now legal, which could ultimately impact background screening if you're used to seeing certain offenses pop up and you rescreen someone. On April 23rd, Delaware became the 22nd state to legalize recreational marijuana. There were 2 bills involved, and they were actually not vetoed by the Delaware's governor, so they became effective as of April 23rd, 2023. Under those laws, the individuals who are 21 and older are able to possess and use up to 1 ounce of dry marijuana, 12 grams of concentrate, and products containing 750 milligrams of Delta-9 THC. However, currently, Delaware residents are not allowed to cultivate marijuana at home, which differs from other laws that we've seen. Employers are not required to permit marijuana use at work or during work hours. They can still drug test for marijuana and act on positive results. Minnesota also legalized recreational marijuana, becoming the 23rd state to do so. The law amended Minnesota's Consumable Products Act, which prohibits employers from taking adverse action against those who lawfully use lawful consumable products outside of work. So beginning August 1st of this year, just a little over a month from now, cannabis flower products, lower potency hemp edibles, and hemp-derived consumer products are considered lawful consumable products. So in other words, those are lawful to consume and they're protected. Also beginning August 1st, individuals who are 21 and older can possess and transport certain types of marijuana in certain amounts. And they're also allowed to personally cultivate a certain number of plants at home, as long as it's an enclosed locked space. Additionally, minor misdemeanor convictions will be expunged automatically, and a review system will be set up to review more serious offenses for possible expungement. While the law protects the off-duty use of cannabis, employers are still permitted to take action against employees who use, possess, and otherwise are involved with cannabis while working, while on a job site, or while operating equipment. They can also prohibit use if it would violate another federal or state law or cause the employer to use some benefit due to being regulated. An employer can also refuse to permit or accommodate cannabis activities at or while someone is working. Drug testing is also impacted, as employers generally can no longer require pre-employment marijuana testing or refuse to hire solely based on a positive marijuana test. There's exceptions for certain types of positions, generally safety sensitive related. Marijuana testing for random testing is still allowed for safety sensitive positions. Reasonable suspicion testing for marijuana is also permitted, which includes post-accident. And then treatment program cannabis testing is also allowed. Employers are permitted to take adverse action against employees who use cannabis during work hours or while at the work site. However, it's important to note that employers may be required to offer rehabilitation in lieu of termination to employees who test positive for drugs for the first time. In case you've not already heard, the Department of Transportation will now allow oral fluid drug testing in its regulated industry drug testing program, which means employers can now choose either urine or oral fluid testing. Technically, this went into effect on June 1st, 2023, but in actuality, it really isn't allowed yet, because the rule requires HHS to certify 2 laboratories to process oral swabs for primary confirmation testing. As of June 24th, when I put this together, The 2 labs were not yet certified, but it's good to know that in the future, once they are certified, that oral fluids will be another option for DOT testing. So this is getting really complex here with marijuana. What should an employer do, especially if it's an employer with employees in multiple states? Always review new and existing laws and consult with legal counsel. Make sure you have your documentation in order and keep it that way. That's going to go a long way to defending if you're following your policies and they're sound legal policies. Keep in mind that marijuana is still legal on federal level. And as you heard, drug testing is being restricted. So make sure that you are permitted to drug test and any restrictions you may need to follow. As unbelievable as it seems, we're already halfway through 2023. So what could happen as we head towards 24? There are already more proposed fair chance and salary transparency laws being considered. So likely when we talk next time, I'll have more to cover. We've already seen 5 privacy laws this year, and there's others that are pending. So again, probably going to see more of those. Marijuana laws will continue to be proposed and enacted. Updates will be made. It's going to create more chaos in keeping your drug screening programs compliant. I do always tell people whenever they ask about what I do for a living, I tell them that background screening is never boring, and that is always very, very true and still the case. As we learn about new information on hot topics, we will keep you updated. Before we take questions, we'd like to recommend some best practices. First, always review your background and drug screening programs to confirm you're compliant with new and changing laws. Reviewing your documentation frequently, at minimum on an annual basis, will help you maintain compliant programs. When it comes to ban the box and fair chance laws, update your employment applications and hiring processes to meet their requirements. If you're subject to pay transparency laws, determine if your job postings need to be adjusted to include pay ranges. As privacy laws multiply, determine how they impact your organization. Finally, focus on new marijuana laws, especially if you have staff in multiple states, and update your drug screening programs accordingly. For all the recommendations provided, we highly recommend working with your legal counsel to conduct a privileged review of your current processes. This will help keep you protected as you come into compliance with any new laws. So we have reached the end of this presentation, and I'll turn it back over to Danielle so I can answer some of the questions that we received.
Thank you, Jennifer. So now I'll dedicate the remainder of the webinar to addressing attendee questions. If you have not had a chance to ask a question via our chat box, please feel free to do so now. Jen, the first question that we have is, when it comes to fair chance laws and clean slate laws, are there any impacts that are not easy to see?
Yes. So it's actually creating an interesting situation right now in the industry, because in general you think, okay, you might have to make some changes to your processes in the beginning, or there may be expungement of records. You might not think it affects you very much. It actually could impact you a lot. So it's actually been delaying turnaround time, especially when it comes to identifier redaction. So if identifiers have been redacted due to fair chance laws or privacy protections, sometimes we're having to go to the actual court and request the file. That obviously will increase turnaround time because we're physically sending someone there, pulling the file, scanning, and sending it back to be processed. Also, if you haven't heard, in Michigan, there's an expungement law that went into place where a bunch of expungements are being automatically, a bunch of records are being automatically expunged. The issue with that is the court clerks are completely slammed, and they're having to make sure that they're not providing expunged records information to background screening companies. So it's taking a lot longer to get those results back because they don't want to inadvertently provide information that they shouldn't. Keep in mind too that when you're running a background check on someone who previously screened, such as an annual background check, for example, if someone had a record that's been expunged, it's not going to show up in the new report, and it's going to create a discrepancy, which can be concerning, but there's a reason for it. Yeah, so it seems that these are pretty straightforward, but they actually cause a lot of other issues that you wouldn't normally think about.
That was a great question. The next question that we have is, hi, for California, for the marijuana drug screening, are there exceptions for employers in the construction industry? Would this apply for the trades such as HVAC, plumbing, etc.?
So I would need to look into that more specifically, but I would imagine that some of those positions would be considered safety sensitive, especially in construction where they're using heavy machinery. So I would imagine that some of those would fall under. It's just a matter of looking at the position. I'll have Danielle send that question to me after the fact, and I'll see what other resources I could provide. And of course, any information I provide is just some non-legal guidance, so I highly recommend double checking with counsel, as they're going to be right in the thick of things and they'll be able to give you the very best answer possible.
Fantastic. The next question that we have is, my company currently does not have any employees in states with pay transparency laws. Should we take any actions to be proactive?
So it really depends on how national of a company you are. If you have footprints in just a couple of states, employees in just a couple of states, it may not make sense to follow pay transparency if you're not legally required to do so at this time. However, if you have employees in multiple states and you're willing to hire remote workers in multiple states, it may make sense to follow the most restrictive pay transparency law just to make sure that you're compliant. So I'd have to go back to the specific laws, but there's some statutes, the way that they're written, where it applies to any remote position that could potentially be performed by someone within that state. So, for example, AccuSourceHR is headquartered in Arizona, but potentially we could hire someone who's going to work remotely in Colorado, which means Colorado law could potentially apply, subject to exceptions. This is just an example. So it really depends on how big of a footprint you have nationally and what your risk tolerance is.
Great, we're almost at the end of our time, so this will be the final live question. Again, if you entered a question into the chat box and we didn't have an opportunity to address it live, we will follow up with you directly post-webinar to provide an answer. The last question that we have is there anything coming up in the future that could greatly impact the background screening?
Yes, so I wanted to cover this in the webinar, but full disclosure, I had too many slides and I had to start cutting back material. Otherwise, this would have been 2 hours. So California, which California is always a problematic state and they're always introducing new concepts, they are trying to limit background screening to where it's required by a statutory law. So for example, if you are hiring an office worker who is not subject to like a health law where they're specifically required to do a certain type of background check, like for the nursing industry or healthcare, for example, you wouldn't be able to request a background check on that person. So in essence, it's really going to ban background screening if this is passed in California. I'm sure that our industry group, the PBSA, is already on top of this and watching it very carefully. And if this continues to move forward, we'll likely be reaching out for some assistance with contacting your representatives to fight against this. But just a heads up that that's something they're trying to do. Don't know if it'll happen, but we've seen crazier things, so I wanted to mention that.
Thank you. Thank you, Jennifer, for facilitating this informative webinar, and a special thank you to our attendees for joining us today. On behalf of AccuSource HR team, we wish you all an enjoyable day.